I'm collaborating with Vibhav. He's an associate partner at Anand and Anand and is also a fellow in AI and law and co-lead of Team India at For Humanity. For Humanity is a non-profit organization engaged in developing AI audit frameworks. Welcome to the show, Vibhav. So, Vibhav, I was watching a video from Alan Defoe recently that highlights how different terms like regulation, policy, bill, draft, etc., all kind of come under the bracket of governance. So, what's your view on this?
Creating guardrails around AI, or if guardrails is the right word, or sort of creating a contour within which AI could operate in a way that is safe for everyone. These terms are thrown around, but I think the governance is perhaps the right word to look at it from the broadest sense, that the idea of governance would perhaps be that you're looking to create rules, and rules becomes narrower to law, but governance would be the broad overarching framework within which AI, let's say managing AI, would fall. But I would like to pick up on those different terms. The policy on the from a perspective would be far more broader, right? And it becomes broader in the sense that it'll cover, it's like a broad vision document, right? So and what ends up happening is that, for example, let's take it from my field. The government published the intellectual property rights policy in 2015. Now that policy I would have at its core IP awareness. It could also have strengthening intellectual property enforcement. It could also have increasing the speed with which intellectual property rights are registered. Now, if you take all these three elements at an IPR, intellectual property rights policy level, what ends up happening is that in a policy, we are looking at a framework which may involve, say, the government. It may involve perhaps an ideas or suggestions for the legislature, or any ideas for, say, what the court system may do. Or when we're talking about awareness, for example, one law college, in the spirit of the IPR, intellectual property rights policy, ended up creating an intellectual property rights primer for people who did not have awareness of intellectual property rights. And from that perspective, when we look at it, so policy is probably the broadest sense, in the sense of what you're trying to look for and how do you engage all different ecosystem players. And it's obviously just it's a broad vision document. It's not, if you look at it from a pure legal sense, it's not binding on anyone, right? Let's go to the next term. If you look at policy, then let's look at regulation, right? Regulation would be something that is, so regulation could be binding or non-binding. Let's, in a very simple sense, non-binding regulation, let's come to AI, for example. Non-binding regulation could be where we are, a lot of these AI principles that have come up over the years, right? You had a lot of organizations publish their responsible AI principles. The OECD, I believe, started off the initial OECD started off the initial publication of rules, right, in 2019. Then if you fast forward, you have the US Bill of Rights in 2021. You have the Niti Aayog responsible AI reports published by the government of India in 2021. So all of these, they would be soft law. They're not binding on anyone. They're just ideas and suggestions in the policy space to get you thinking on how AI could be regulated, or how AI could, the different angles and perspectives in which one can think of AI.
So, Vibhav, I'll just pause here. Like, I'll ask a
Sure.
question which is lingering on my mind. So, policy could be at a broad level, and because regulation also could be binding and non-binding. So, the policy
Correct.
which is non-binding could be at a very high level, but is not giving you the go-to steps on how to handle a particular situation or the risk that arises from the use of AI. But regulation still gives you that approach or methodology, even if it's
Right, exactly. So I mean, these are very fine distinctions. Perhaps policy and regulation, there might be an overlap, but what I'm trying to highlight is policy is broader,
Okay.
Narrower than that is regulation. Then regulation, you have binding and non-binding.
Hmm.
The reason I've said non-binding regulation is because, especially in the AI space, we don't have a law as on
Yeah.
date that regulates AI, and there's a lot of material out there, a lot of principles, guidelines out there which don't qualify as law. But
Okay.
if you are proactive, you may look at those regulations or those principles to become more aware of how you want to develop responsibly, if it makes business sense, because one can't even say whether those things that are published out there, whether they are practical or not in that sense, because they've not gone through the process of becoming a law. They are just suggestions and recommendations. That's the non-binding element. Now I would say that bill, law, or regulation, that now the binding element of it, right? That's where it starts overlapping a little bit.
Okay.
Yeah, please tell
Just to
me.
interrupt you, like we'll just take baby steps onto these, right? So on regulations, the non-binding one, for example, is it similar as, okay, so who gives those suggestions in the first place? Like you mentioned, these are just the suggestions. Which forum are these coming from? Is it coming directly from the citizens who are using it? Or there are some authorities who decide, or maybe group of authorities who come together and decide, okay, these are the ways that we find should eventually go down the path of becoming law. So these are the approach which is eligible on the path of the legal implications.
Right. So in the context of AI, let's take AI as the example. In
Okay.
AI, a lot of these principles initially were released by organizations themselves. I think in 2018,
Okay.
2018, 2019, they started. 2019, you had the OECD that published principles. I believe there are about 70, 80 principles as recent as, I mean, in 2020, I think there were about 70, 80 principles. Different organizations had given their perspective on AI at a very broad level on how they want to do this. Then, and the reason I'm calling them regulations is because in the absence of any hard law or any law, so regulation, when I'm saying non-binding, which means it's voluntary mechanisms, they're not, so in a way, if you call them regulations, it's more of, they don't have an imprimatur or the approval of any government. They are just suggestions in this space. It could be a private organization, it could be a body like the OECD, it could be the Niti Aayog, which is a think tank, it could be the US government through the US Bill of Rights, it could be your national AI strategy paper or something of that sort published by the UK government, or a consultation done by the UK IPO. The reason why I have clubbed them in regulation is in the absence of any actual law. A law, let me go the other way around. A binding law would be one that would, as per the relevant country, get passed by that relevant legislature and by the relevant legislature and get the assent of the president. I'm talking here in the Indian context, right? For how does a law in India get created, right? You would have a bill, which is a proposed law. Then the bill would get presented before the parliament, and it will get presented before the Lok Sabha. Then it has to pass the Lok Sabha, it has to pass the Rajya Sabha, which is the upper house, and then get signed by the president and then get notified in the asset. And of course, between this process, it's a long process. It takes time. That's the point. So there, when you have the president's signature, that then becomes your law, right? But the reason I put soft law in the category or non-binding law in the context of AI in regulation is because as on date, we don't have a law on AI. You might have existing laws extending to AI, but if you're talking about a pure law that covers artificial intelligence, we don't have it. What we have is a draft, which is the draft published in the EU, in the European Union, which is the EU AI Act, which also then is a draft which will get, it's going, I believe it was voted by the European Parliament. Now it's in that trilogue process, which is specific to EU. EU itself is limited to 27 countries, right? So from that perspective, that's the distinction. So your policy very broad. Then you have, of course, I've put in the context of AI, I've put non-binding instruments in regulations, soft regulations. Maybe it might be not even correct to call them regulations if perhaps people think that regulations is something that has to necessarily stem from the government. Then in that context, perhaps a bill and a non-binding regulation would be, the proposed law could be considered as a regulation, right? So that could be the thing. We could even perhaps another category. We could have policy. We could probably have guidelines, which are
Yeah. The
non-government.
frameworks.
Yeah,
Yeah.
the frameworks, right? The guidelines and frameworks, non-binding elements. Then we could probably have regulations, which we could have both proposed laws and past laws, because binding elements will then be there. And then you of course have your bill and your law that gets passed. So different gradations there.
Yeah. And do you think that, because like you also mentioned that in formal terms, we don't have as such an AI law, right, existing today. In the absence of that law, what is your opinion? Again, it's a matter of perspective, right? What is your opinion that the tech giants or the developers of foundation models, talking in the context of generative AI as a technology, how easy it is for somebody to self-regulate themselves? Because you somewhere mentioned about voluntary regulation as well, right? So one is that OECD and other consortium, global consortium of the associations, they come together and they kind of propose something. Now it's on to somebody or incumbent on some developer or the company who is developing those systems to follow them, or maybe feel the need to follow them, right? If they think that they have their vested interest in the larger purpose of the technology being put to the right use of humanity. How easy it is for someone to first self-regulate, and if they want to do, what would be the approach? Like, no one knows. I mean, I don't know, the majority of the audience knows.
Right.
All those things that we get to hear is a very broad term. The pillars of responsible AI, we all are aware of. They are very broad terms, but to make them put to use in at the ground level, it's very difficult. So what exactly these tech giants can do?
Right. So I think first the underlying premise that we have to understand in this is that AI is unique in the sense that the technology is evolving.
Yeah.
And your understanding of legal frameworks are always legal frameworks, even if they are not precisely going into the minutiae, if they're not getting into every single nuance, do need to be framed within a certain level of certainty, right? For example, let's take the digital personal data protection bill for personal data rights. We know that that bill is seeking to protect personal data of citizens.
Yeah.
How it is sought to be done, what rights are going to be given, what rights are not going to be given, that's part of the proposed law, and there'll be back and forth on that. But we know what we're regulating. We're regulating personal data of citizens. AI, on the other hand, when we've brought up foundation models, right now, AI, on the other hand, is in this peculiar spot where we have technology development taking place. Along with that, simultaneously, we are realizing that there are certain risks that are present from this technology. Along with that, we have lawyers trying to understand those risks. Also, or lawyers is a narrow term. Let's talk about the entire ecosystem that is trying to build guardrails. They're trying to understand the technology. They are trying to understand how it's evolving, and they're also trying to understand how to regulate it. So to answer your question, it really depends whether in some situations self-regulation may work. Some situations it may not work. It'll depend. And the reason why it says depend is because when you're talking about regulation will encompass the entire thing. Regulation will not take a specific instance and reverse engineer from there and then give you a law, right? It won't take an isolated incident, say, of biased result. That will be an important part of the regulation. But it just won't be that it created a biased output. So I take that one end goal as an objective, and then I go backward from there and I just make a law just focused on that, right? That will be part of one framework that exists, which is why it's a combination of everything. So because you have, the law also has to take into account the practical way of doing things. It cannot be so it's a balance, and therefore this requires a significant amount of consultation and all. So I would say that when we're looking at self-regulation, it's a good start, at least from organizations, because it at least gives people an idea that they're looking at a macro context. However, once those AI applications start moving forward and you start moving along further in the journey and you develop it further, then perhaps as the legislature gets a better understanding of what within their existing system, how they want to regulate that, then the regulation can be blended in. So I don't think it's an either or an or. It's somewhere you have to meet midway. Regulation may cover some things, but the regulation, the law may cover the proposed law. Let's keep it simple. The proposed law may cover some elements, but it's possible that the practicality of that development may still not be covered by the proposed law. I mean, this is getting slightly broad and vague in that sense, but this is just the broad way of looking at it, right? So, for example, let's take an example, right? If you have a generative AI tool, now when you have training data in there, right? Now, when you have training data in that, let's take an example from IP.
Yeah.
And now you have existing laws that cover copyright law, right? You have copyright law which protects artists, which have protects authors, protects computer programmers for the code that they write.
Yeah.
Now let's assume that their data was taken in the training data set in a generative AI model, a generative AI tool, and the generative AI tool starts producing an output being trained on copyright protected data. Right? Now, at one end, the existing law would say that there could be a claim for copyright infringement. And in fact, there have been cases that have been filed in this space, right? Simultaneously, there could be a counter argument that when the AI system is being trained on that data, and its conversion in the AI system, in the black box, and the way it's converted, and the output that is creating, perhaps in the legal sense, is not meeting the legal test of being substantially similar. Or perhaps it is meeting the legal test. We can't say. It'll depend on the facts of the case that are being fought abroad. But the point I'm trying to highlight from this is that when you look at self-regulation, when you look at laws, existing laws may cover certain elements of it, right? Existing laws may help bring in a claim for copyright infringement for an IPR infringement. Similarly, existing laws would also simultaneously give people a defense, right? Because it's changing its nature while it's being trained in the tool, right? In that scenario, sometimes for the gap, from my perspective at least, having an awareness in terms of self-regulation, having awareness of the broader picture, being aware of the laws, simultaneously being proactive to build your own guardrails, both work. It's not a complete answer. It's not this or that.
Yeah.
Hope that was a long answer, but I hope it gives you some sense for the listeners, and just to get the sense of the difference between the point that you asked.
Yeah, Vibhav. So the example that you take, I think this is more relevant for our conversation because the theme is generative AI. But what I want to know is that for copyright, if it is an issue or it is not an issue, there is a particular government or maybe government authority for our country that decides. Is there a point of convergence, to be put simply, that across the globe, everyone thinks that there is a copyright infringement happening because the underlying data that is being trained on is curated from the internet, which includes the fractional inputs from all of us taken together, and that's breach of the policy or some sort of law, right? So is it like this particular case, like it's either yes or no, right? There is no gray line in between, I would say.
I would say that there is a lot of gray.
There is a lot of gray
Yeah,
across the
because
globe, like
no,
moving
see,
away from India and other countries as well. They'll not consider it through the same lens.
No, they'll consider it. The risks is this: the risk of getting of there being a claim for copyright infringement is the same across the globe. I'm not saying that there is a claim. So what has happened right now in the US is there's a claim for copyright infringement that has been made, right? It's a claim. Again, I'm coming here from a pure legal sense. Claim means I'm alleging something, but then that has to be proved by the person who's made the claim. Simultaneously, the person against whom the suit has been filed they may have their own defenses. It goes back to the example I just made. For example, I got the AI model got trained on IPR protected data, right? But after being trained on that data, the AI system worked in its black box and it generated a particular output, right? The fact that I'm able to prove that it was trained on copyright protected data, of course, does give me a chance of bringing a claim for copyright infringement. Like it took images, it took my books, it took my code, right? That was available. That brings in a claim for sure. But I won't, as a practicing lawyer, I won't say that merely bringing a claim means there is copyright infringement, because the court has not issued a ruling yet. We don't know how the court will decide on that issue. But yes, if you're looking at it from a business perspective, of course, because a claim has already been made for copyright infringement in such a scenario where training data has been used from public sources, it does present a risk. And therefore, if I am working in this space, and if I am scraping data from online to develop my model, I must be aware of the risk, and perhaps I could take steps to mitigate that risk in terms of, perhaps on the technical side, we'll have to figure out what those mechanisms are. But at least perhaps I believe in data sciences, when you're cleaning the data set, where you have an awareness of where you've taken the data from, and it's about mitigation of risk, right? In that sense. So that's the point I'm trying to highlight. And so there will be a risk. What these cases highlight is definitely the existence of a risk. Now we move forward, and let's assume the claim has already been made, right? Which is the claim for copyright infringement and all of that. Copyright infringement for like copying of books, copying of images, copying of all of the elements. On the other side of the spectrum, they always have a defense that the after training, the 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 input is getting transformed in a way that it may, under the US law, qualify as something which is fair use, which is not copyright infringement. So we can't decide either this way or that way. It'll depend on how the court decides. But at a practical level, this example at least tells us about how we must be aware of that risk, and what can we do with that awareness to mitigate that risk, or what advice can we take, what steps we can take.
So the context that I want to bring, Vibhav, is that claims are being made. Today we are discussing about the claim maybe made in the US. My thought to understand the process is that same claim, if it is made in some other geography or country,
right,
the law of land changes, and maybe the result to the same claim is different at two places. One country's law may say that because the data got processed at such a level that it's no more eligible for copyright infringement. Other says no, it is still, because there is no significant processing done so much so that it's totally reformed or reshaped. So that particular element is not straightforward, you mean to say. So it's based, the reason is that we don't know which country data has been scraped to make what, right? So we don't know what is that component contribution or constitution of that data coming from, because it's all of us taken together, if I have to put it in a very broad manner.
correct.
So, and this is something which is transcending boundaries. This is right. So it's not limited to particular boundaries. So this creates a lot of confusion. The makers do not know, the people who are leveraging these tools do not know, the person who is making the claim doesn't know what went behind it. So when we don't know the origin of it and how to stop it, because it's at such a massive scale, just finding those things is difficult in themselves. How would authorities take the decision of declaring it as a risk or not? Or it is a risk, but not giving a judgment, which maybe the people who think for them the infringement has happened, they feel that it's been, the law is being justified to them.
No, so first of all, there is a risk. So whether there is a decision, if you're talking about a risk identification, there is a risk, and therefore the analysis of that risk has to happen in a specific way. I'll address this in two parts. One is the existence of risk, and the second part is how would the authorities decide, right? So when the risk exists, then it'll have to come down to the individual creators' role. How are they developing it? What are they developing it for? Who are they developing the generative AI tool for? Where are they getting data from? How do they manage to use the tool? What licenses, obligations? That's a very fact specific exercise which can't be answered in the abstract. The risk aware, I think from a perspective, risk awareness is important. It cannot be, so you have to kind of work with someone and work through with your lawyer, or work through with any other person that you may want to consult with, but to identify that when you're going through this entire process, what all steps do you want to protect yourself from, right? So you could have a copyright, you could have an IPR protection risk, you could have personal information there, which might be there. But again, those answers will keep depending upon which jurisdiction you're operating in, right? Where do you put your tool in the market? Like, for example, if you've the training data set maybe from X place, but you're putting the tool in, say, a particular territory which may have their own laws, then in that scenario, how do you, what mechanisms in that relevant legal framework of that particular territory, what steps do you need to take today? It's sort of a risk mitigation exercise very broadly, right? Nothing, and it's managing those risks. When you're, so that's the broad level. At when we say that, we'll know that it's scraping data, and there are these element of risks. Now when we come to the second point, how would the authorities decide? There are specific cases filed, I believe, in, I think, in the District of California, Northern District of California, 3-4 cases, and I think there are a couple of cases filed in the UK as well. There the courts will decide. How they will decide will depend largely upon the lawyers that present the case, the facts that are presented to the court. Because in the legal realm, these things are decided predominantly on the appreciation of individual specific scenarios and facts. I understand that when we look at this, what you're questioning or what you're aiming for is complete, precise clarity, that give me a clear answer. What am I supposed to do right now? I think that answer will emerge with passage of time.
Yeah.
I think the important point to realize over here is that when we've moved from AI to generative AI, there are these different types of risks. There is an IPR, intellectual property rights risk. There may be a privacy risk where personal data, your personal data might be part of the training data set. There could be cyber, when you have the tool, you obviously have cybersecurity risks as well, in terms of it,
Yeah.
of the AI model itself being disturbed. So when you look at it from a legal lens, legal elements are identifying a particular element of risk that is present. I think that identification is equally important, and then you have to figure out from your own scope, within whichever market you're operating in, how would you like to mitigate it.
Yeah. And what bothers me is that if someone can get away from the same issue because of the authorities or maybe the laws that govern that place where it is originating from, and the other person might not. So it looks like, considering just even the same case, not the nuances of the case being different, and then we are talking about the case being handled in different territories. The territories might be different, but the case if it happens to be the same, the verdict might be different. So it's like,
absolutely that's the case with any area of
yeah.
law.
Yeah, but the convergence is not going to happen anytime soon. So we can't see a global consensus on this. That's what you mean to say, right?
That goes back to the earlier part of the conversation, right? That when the technology itself is developing,
Yeah.
and the law and your understanding of law, for let's take the example of EU, just to bring this back, right? The EU AI Act was proposed in 2021, and it kept progressing, right? But the minute generative AI tools emerged late last year, you ended up, the speed with which they wanted to pass the law increased.
Yeah.
The definition of AI itself was changed and made in line with the OECD definition of AI, so that it could cover generative AI tools, right? I'm using this as an example of where, when you are, and this was, so chat GPT or generative AI in that sense in public consciousness came around in November 2022. We're in August 2023, right? So let's take in terms of timelines, right? So the EU AI Act was proposed in April 2021. 1.5 years later, in November 2022, do we have chat GPT or generative AI that comes out. Then while you have worked for 1.5 years on the law, learning on this particular technological advancement, you go back, and in early 2023 or March 2023, I think earlier this year, they changed the definition of AI to make it consistent with the OECD definition. And then they the European Parliament passes the law in June 2023, right? So the point I'm trying to highlight is that this is an area where even the way the law was made was changed at the last minute by greater awareness of how the technology may be used. And therefore, that goes back to my original point that I said, that I'm not convinced that self-regulation does not work. Self-regulation will continue to address at least some element, because self-regulation as the way it exists is emanating from certain practical elements of uh, or certain desires perhaps of developing the technology in a particular way, good, bad, ugly aside.
Yeah.
In that element of self-regulation, when you create that, you would obviously, it's possible that the proposed law, let's take EU only for example, may or may not cover everything that is practically happening on the ground at the grassroots level. Therefore, in that situation, perhaps the self-regulation guidance perhaps may fit in with an existing law in that sense. So that's really what I'm trying to say. It's what I'm trying to say is that the self-regulation is emanating from a practical perspective, from a developer who's developing an AI system, and the law is emanating from the potential misuse of the tool, and therefore both are functioning together. It can't be either or.
Absolutely. For me, self-regulation is a way. It's more like prevention is better than cure. So it's like when you're self-regulating yourself, you're making sure that whatever potentially can become a risk later on, you're handling it right at the origin, which is similar to that 1-10-100 rule. So for example, if you're doing an error or letting the cost of error prevail and it goes downstream, then the cost or the penalty you pay for that risk to keep flowing right into the community or to the humanity, it's like increases exponentially. So when you're regulating yourself in the first place, obviously first perspective is what I believe is that no one community can think through all the possible negative impact or implications of what their product might bring into the society. So for them, thinking through this wide and large on behalf of all entire population of the world is difficult. But even if they have some mechanisms to control it, you're controlling at least, even if it's a fraction of it that you're controlling at the origin, I think you're still, making very less of the things going down the funnel, which can potentially become a problem, which again, there are measures that will control that. So it's more like a funnel process. You stop it right here, certain percentage flows through, then there's another process that kind of stops that from percolating into the society. So that's what I generally think of self-regulation, that the more things you control at the place where the sources could be, the better it is for everyone else who is associated to handle that problem. And so I think that's one thing. And I think we started that copyright thing, no? So maybe that's more related to generative AI, like taking a step back. What I have a concern is that AI existed for long. Like you can't say generative AI because it came in November 22 and the people are just racing towards making sure that we have laws in place effectively, which adheres to the current definition of AI. So, talking about the broader definition of AI, it existed for long, and there were risks that we all were seeing it from, times forever or something like a long period. What was stopping all of us to not think about those risks, and why we are thinking, okay, why maybe I understand with generative AI because the power is in the hands of the user. Everybody knows about AI like they never knew before November 22. But what exactly maybe the other people who are concerned were stopping them from just having it as a guideline or something, but not having something which is as stringent as a law. Had it had been there, then maybe there is a small revision on top of that would have been required to address the exacerbating risk which are coming from generative AI. But what's your view on that?
So I think the answer to this question, really goes to the origin story of how AI developed, right? So the term is developed in the term for our listeners would probably it's way back in 1956, right? So I think the answer to this lies in the distinction between artificial narrow intelligence and artificial general intelligence, right? The idea of AI in 1956 was to develop machines that could think and act like human beings, and therefore you had the research goal of artificial general intelligence. And then there was a winter, I believe in AI winter in the 1980s. Machine learning existed as a concept. And when I'm giving very broad strokes of the technological development here to address this question, right? So we have the term made in 1956. We have the concept of machine learning. We move to 1980s. 1980s, we have a AI winter. Then I believe later deep learning comes in, computing power improves, and then you have the ability to detect patterns from large amounts of data. And then you have what was called the data quake or something in 2012 or early 2010, 2008, 2009, 2010. And I believe you start seeing these applications emerge in 2017, 18, right? That's a long period from 56 to 2018. I think that the pace of adoption of AI, the ease with which AI can be integrated in products, services, in day-to-day operations, I think that has significantly increased in the last 5-6 years. And I believe that generative AI has provided the necessary impetus in terms of the urgency to try and regulate it after it reached public consciousness at that level. There was conversation. If you would look at, so it's not as if nothing happened. If you look at all the, as we spoke about regulation policy and all the draft principles or principles that organizations published came out in 2017-18. The OECD principles came out in 2019. India itself published certain responsible. First, India published a national AI strategy way back in 2018. Then we had Niti Aayog publish responsible AI part 1 and part 2 paper in February 2021 and August 2021. Then we had an application of one of those responsible AI principles being published in the context of facial recognition technology sometime in October 2022 or November 2022. And simultaneously, another framework being published by the Telecommunication Engineering Center, one of the government bodies, on AI risks in December 2022. So if you see from 2018 to December 2022, irrespective of how AI adoption is happening, you have certain documents. They're not laws, they're just voluntary compliance, they're just papers there for you to get a macro picture of it. But you are seeing a consistent sort of development in this space happening from 2018 to 2022. And in India, where AI adoption and AI training and all is happening, it's a good, strong tech talent, but it's developing. But at an application level, it's not this currently still not the same as perhaps US or EU. And we're looking at day-to-day applications, right? So with that background in mind, the point becomes that perhaps the only change that one can see is the urgency. I don't think efforts were not being made. I think there were efforts there, but I think awareness increased once it came to the user, like you said. Once that awareness increased, the impetus to push forward proposals that were already existing sort of increased. So which is why now everyone for the last 4 months or 5 months has just been talking about regulation. Like just everyone's talking about it. So it's sort of a change that's happened.
Yeah, I think that's true. Okay, so because we are talking about regulations, and I believe as we are talking, maybe the dialogues are happening, there are a lot of action is happening also on the ground, right? Because historically it's proven, it's empirically evident that the development or the technology which hits the market, the rate at which it hits the market is faster than the rate at which we are able to regulate it. I think that's prevalent all across, no geography taken.
Correct. And that's not necessarily a bad thing. That just depends, right? I mean, sometimes you need freedom to work in the absence of regulation also. I'm not saying, I mean, it's neither here nor there. So we can't say that's a good thing or a bad thing. If you over-regulate, some of the developments may not happen. At the same time, regulation must keep in mind the risks that are happening. So it's a bit of both.
Yeah. And what I think is that there are two ways whenever we talk about risk, right? Because I've done financial risk management also. So the definition of risk is sometimes it's foreseen, sometimes unforeseen, right? So when a law is being made or we are thinking of regulating any technology, AI, generative AI, advanced algorithms, right? What all can a person foresee, or how visionary can one community be or a consortium be, that they have thought through all the possible cases that it can cause damage or it can create havoc or lead to catastrophe, as people call it, that we have accounted all of them to a majority portion as much as possible today while drafting law, or maybe in the process of creating a law, right? So that unforeseen is what comes and it's taking everyone by surprise, and that's handled, I think, on a case basis. But how is it possible for you to not actually let the harsh reality come true, and then you say, oh, I hadn't thought through this, and let me just embed it into what we currently have as law.
Right. So, okay, first, I think the premise is that the risk will never be zero. This is a
Yeah.
constant risk mitigation exercise. That's a fundamental premise you have to start with. I think
Okay.
it will never be a situation where it's perfectly zero.
That's why I use the term majority. Majority of the risk, if I'm taking care of, and I can say that, okay, these much I could think through, or maybe we as community could think through, and whatever extra is marginally left out. So that's what I'm just saying, majority taken care of, marginally being left out. Let's start from there.
Right. So I think again I'd go back to the non-binding guidelines
Okay.
because I think they would I view those as at least articulation of the different types of risks that may exist. For example, safety and reliability,
Hmm.
right? You have to deploy reliable means that it's giving the end result that it was trained to.
Hmm.
Safety means it is the tool is from a cybersecurity perspective, from a breach perspective, that level of expertise has gone into it. It could also be that and then there could be ensuring that it doesn't give or ensuring or doing your best to ensure that you've addressed the issue of bias. It's not giving a biased result, right? For example, the EU AI Act talks about the testing data set, a validation data set, and all of those different terms to check out to sort of cross check the output that your AI tool is creating. You could also have privacy protection,
Hmm.
right, where you are protecting privacy of individuals, right? Then it could also have subject to relevant protection of relevant laws, being able to have an explainable output, right, if it's possible, practically possible to provide it. It's a very complicated debate given to understand, but assuming that one can give an explainable output, or you have a good trail of of how the AI system developed, right? So all of these different elements that I'm talking about, and I'm going to come to the the trail part in a minute. But all these five things that I said: safety, reliability, ensuring for a biased result, non-biased result, privacy preserving, all of these are emanating from, say, the just the principles of responsible AI that the Niti Aayog published, right? It allows you to think in those different directions, that what am I supposed to do to minimize risks? Because these risks have already been identified as a
Hmm.
part of these guidance documents that have been created. Now let's go a little deep further. Let's delve a little deeper, sorry. Now, when you go delve a little deeper, you are in a situation where, let's take, for example, the GDPR, right? Again, in the European context. But the ICO, which is the Information Commissioner's Office in the UK, called out for an AI audit scheme. An audit scheme and AI audits, which is basically that they wanted to build in personal data to the extent it is being processed by an AI system that can be that's being processed by an AI system. To comply with the GDPR, you build an AI audit mechanism. So this isn't in the absence of a law. This is like, but this is what For Humanity is doing, right? They've built an AI audit criteria. So AI audit criteria, very simply put, right? First, the concept of AI audit. You have third-party criteria, which is an audit criteria for that. The audit criteria is based on a law, right? So it's more like a compliance mechanism with the law, and then people are trained on that audit criteria, because audit criteria means it's a black and white scenario where you know whether this element of the law, if it has an audit criteria, if a particular provision of a law has an if that particular provision of law has an audit criteria, what is the way to satisfy the audit criteria, how do you comply with that. So that creates sort of a check mechanism through an audit criteria, right? So that's
Because
just
one thing, so these audit criteria, at least they are universally applicable, right? Or they are also case specific or
they
job.
would they would be the audit criteria would be. So the audit mechanism, how that functions is, it happens in first answer to that is that it will be law specific. There will
Okay.
be an audit criteria on the GDPR, They
Okay.
can be an audit criteria on the EU AI Act. They can be an audit criteria on the Digital Services Act. They can be an audit criteria on the New York City Automated Employment Decision Tools law. All of these four are already happening. For Humanity is working on these audit criteria,
Hmm.
right? So when you have these scenarios, what ends up happening is that it's one way. So it's going back to your question: if I'm developing an AI system today, what am I doing today? How do I do it?
Hmm.
How do I work on it, right?
Yeah.
Some guidance I will get from general laws. I must not violate existing criminal laws. I may not should not violate existing intellectual property laws, should not violate existing data protection laws. But
Hmm.
those are general laws that exist, and you will need legal advice to for your lawyer to understand, or whoever you're taking advice from, how what you're doing, how that intersects with the existing law, and how you must then not fall foul of that law in terms of compliance. That's one element. That's how majority of would be operating when you're looking at law and technology today.
Yeah.
But if you look at it differently, if you look at it in a pure AI bucket, like only forget all the laws and we're just looking at AI,
Hmm.
then that only EU AI Act only exists as a model, which is the only AI specific law. Of course,
Hmm.
you have NYC automated employment decision tools, and there are other state laws that also touch on AI.
Hmm.
But what I'm talking about, and even existing laws in India would touch on AI in some ways or the others. But the point is that I'm looking at a comprehensive AI regulation. That's the EU AI Act, right? And taking a leaf from the EU AI Act, providing guidance to an AI developer is what I'm suggesting through this concept of an AI audit.
Okay.
Because an AI audit is looking at five pillars. It's looking at ethics, bias, privacy, trust, cybersecurity,
Hmm.
and it is built on a concept of a committee structure within an organization. I'm not saying we don't know whether all of this maturity exists within an organization or not, but we're talking, but it may already exist. We don't know that,
Hmm.
right? But we're talking about, for example, you have an algorithmic risk committee. Algorithmic risk committee is which is capturing, because you're talking about an AI audit, you're talking about an AI system that is looking at processing of personal data in the AI context. You have an algorithmic risk committee, which is a committee that is capturing the risks that may be there in an algorithm. If the AI tool is using children's data, then you
Hmm.
have a children's data oversight committee.
Okay.
Then you might have an ethics committee. Now, all of these different committees depends on the maturity of the organization, depends which geography I'm operating in, which organization I'm working with. But it's just a broad idea in addition to existing laws, proposed laws, of what I could do
Hmm.
or what we could do when you're thinking purely in the AI context.
Got it. Got it. Yeah. I think what I was thinking was that because again, I might be wrong, right? So I'm just thinking out loud. So because audit is kind of latched or attached or roll back to a particular law, which necessitates that the law for a particular thing exists right in the first place for you to audit, right? So I'm just thinking that what would happen in those cases where you don't have law in the first place, but you still want to get audited internally, externally, or maybe from a third party. So just was picking thought on that, and maybe I realized that it would be a good way to at least crowdsource the auditing criteria and then have that as your first initial preliminary baseline auditing
Yes.
criteria for the
So
company.
so
Yeah.
so so a lot of the audit criteria of for humanity, the entire criteria is crowdsourced. That's one. Two, what you're when you're looking at diverse inputs and multi, so what you're talking about, diverse inputs and diverse for assessment of risk, right? The
Yes.
point you touched before. That's also an important element of that. That's called diverse inputs and multi-stakeholder feedback, or in the for humanity context, that term could be called something else
Okay.
elsewhere. But the idea is that I need to have diversity of thought, lived experience, and concepts within the room,
Yeah.
right? For me to be able to identify the different risks that may emerge.
Correct.
That's obviously an essential element in all of this, right? I mean, a homogeneous group will not. So the question that is that who is not in the room
Yes.
and why are they not there, right? But again, so that again becomes a very broad thing. The entire purpose, what we're doing in this conversation, we're trying to identify actionable items as in what we can do today, and that is why that will come in. I mean,
Yes.
from my perspective, from proposed laws or guidelines or existing or draft audit criteria, because you have to think in that space. This is one of those spaces, I think, where a lot of it will depend upon an ability of a person who's working on AI, the ability to think ahead, both in terms of course, technological development, but
Yes.
also the gumption or the desire for risk mitigation. It'll never be zero, but the extent to which you want to go. Because if you're looking at waiting for the law and then waiting for complete clarity, I'm not quite sure this would be a place. This AI is an area, considering its application and its potential for misuse, and is an area where one can wait for complete perfection before acting, if one is looking to develop it.
No, that's absolutely, put in the very right tone, because what I believe is you have to start the conversation from somewhere. It's a baseline conversation. It's a lot of perspective driven also. So that's what my intent with this conversation also, which I think I'll roll out tomorrow or day after as I get time, because I need to now edit this. A lot of people could not join because of the streaming issue, but when they'll get to see this, my intent originally was to bring awareness of what is happening in the regulatory space, because you get excited seeing the possibilities, but you also get scared seeing that there could be an implication just because it's not going right from the humanity perspective, or because you could be held by law or proposed law or whatever is going to come now later into the future. So that's awareness is what's going to keep the ball rolling till we actually